You ready? I'll start recording this one. 3, 2, 1. We're live. Go.
So we're very, very honored that Rabbi Zimmerman is joining us tonight. The pasuk says, "Ve'ela hamishpatim asher tasim lifneihem." These are the rules and laws that you should put before them. So Rashi tells us, what does it mean to put before them rules? So Rashi says two things. One thing he says is, asher tasim lifneihem, you should put it before them. There's like a set table, like a shulchan aruch, like a set table. In other words, Hashem is telling Moshe Rabbeinu, Hashem is telling Moshe that when we're taught Torah, when he's teaching us Torah, it should be in a way where everything is set before us. It shouldn't be we have to scratch our heads to figure everything out. You gotta explain everything. We're simple people. You got to explain it to us. You got to put everything. That's one explanation. So that's me. Everything has to be a set table. Shulchan Aruch, a set table. The other explanation he says, Asher tasim lifneihem, should put before them, before a Jewish court, and not before a secular court. In other words, you have an item, you have a dispute, and that dispute, you can bring it to court. See you in court. You're fired. Right? That's one option. Says the Torah, if you have an option, if you're dealing with another Jewish person, you have an option to bring it to a Jewish court, don't bring it to a non-Jewish court. Don't bring it to the secular, bring it to a Jewish court. And so, I saw once, remember what I saw it, and I saw there was it says, just like we're careful, a lot of times we're careful about the food we eat, to make sure everything we eat is 100% kosher. Of course, we should always do that. Just like we do that, we should make sure the laws that we keep are also 100% kosher, and that we should. Question is, we all do some type of business, and we're not sure how to go about it. How do we want to take something to a Jewish court? We're lost. We don't know. We're left in the dust. How do you say it? And so we're honored that Rabbi Zimmerman is here tonight, and he's going to tell us, he's going to explain us what the process is, explain us how it works. And Rabbi Zimmerman is the HaRav Beis Din, he's the head of the court in London, right? And before that, he was in Gateshead and Monsey HaKodesh. Gateshead is also HaKodesh, right? And so it's a great honor. Also, I want to give a thank you to the law firm, my friend Bob Stack, and law firm of Stack, Khan and Bremerman for sponsoring the series, and to the Kehilas, North Miami Beach Kehilas, for putting it together, and also to Barry, our friend, Uncle Barry Snyder, from Barry Snyder and Associates ESQ, for sponsoring the Olanash refreshments. So I think I should reserve. Oh, right here. Oh, perfect. I should look inside. Yes, well, we have questions. Yes, I think is it fair to say that we should do the questions at the end? Yeah, that question at the end. And before that, I don't know how. Everyone have a phone? So my phone has a button on the side over here, and I go like this. I can put it vibrate, or I can go all the way and it's completely silent. So if you want to check if it works with your phone, that would be great.
Good evening, Rabbi Feivel. Just as a way of introduction, my name is Shraga Feivel Zimmerman. I live in London. I know you're expecting a British accent because everyone in America thinks that British people sound exotic. And however, I grew up in Brooklyn. I lived in Monsey for 20 years, where I was a HaRav there. I moved to Gateshead about 15 years ago, and I was the communal rabbi of the town of Gateshead. And about 3 years ago, I moved to London to be the HaRav Beis Din, or the Chief Justice of the Federation Beis Din of London. And in that capacity, I try cases on a regular basis, probably do 2 dinei Torah, that's financial disputes, a week, one divorce a week, and the rest of the time we run the kashrus and the chevra kadisha. So full cradle to grave service. Now, and what I would like to speak about tonight is the process of a din Torah. As the Rav said, Pasuk Parshas Mishpatim begins, Ve'ela HaMishpatim. These are the rules, these are the laws, Asher Tosim Lifneihem, which you shall place in front of Klal Yisrael. And the Pasuk is saying two things. One, there's a list of rules, of laws, that's the Mishpatim. Two, these rules should be placed in front of them. And Rashi explains, Eila Mishpatim will be found in the rest of the parsha. These are the rules. So what does it mean, Asher Tasim Lefnei? And Rashi says that even if you know Lefneihem, you should take it to a Jewish, adjudicated in front of Jewish people, in front of a Beis Din, V'loi Lefnei Daim, and not in a civil court. Va'afilu yadas b'din echad shehem danen oisei kedina Yisrael. Even if you know the result will be the same, the rules are exactly the same. In other words, someone who wants to be Monsey, someone who wants to acquire possession of something, the burden of proof is upon him. Like they say in civil law, possession is 9/10 of the law. And in Jewish law, so if you want to make a claim, you have to prove it. The burden of proof is on the claimant, not upon the respondent. Nevertheless, even if you know that the law is the same, nevertheless, you should bring it to a Jewish Beis Din and not to a civil court. So what the Pasuk is telling you, what Rashi is teaching us, is that there are really two factors one has to consider before going to a civil court. One is the law system the same. You can win a case in court, but it could be that in Jewish law, you're not entitled to that money. And if you'll do so, the avera you're doing is just like sigzol. You're stealing money. In Jewish law, you're taking money you're not entitled to. Then there's another thing. Even if we'll say that the law will be the same, the result will be the same, nevertheless, it's an avera to take it to a civil court when a Jewish court can adjudicate. And this is found in Choshen Mishpat Siman Chavav, and he says very harsh words about it. He says, "Osa lodoin b'fnei dayanei akum bar koshem." You should not. It's prohibited to judge a case in civil court. Va'afilu b'din shedanin kedin Yisrael, even if the result will be the same. So there's no issue of stealing money or acquiring money which you have no right to. You can't. Va'afilu nisratzu beis balei dinim ladin lefneim, even if it's by mutual agreement. You're not forcing someone to go to court. You both want to go to court. It says in Siv Gimel, even if you signed the contract in advance that we're going to adjudicate this in court, nevertheless, you're still not allowed to do so. And the Shulchan Aruch says very harsh words. And if you do it, Russia, person is evil. It's as if you blaspheme Hashem. What you're saying is that Jewish law has nothing to offer. I need civil law. So what we're saying is that if there's a dispute between two Jewish people, it should go to a Jewish Beis Din. And even if they signed an agreement that they will adjudicate it in the court in the state of California, you still have to take it to a Jewish court. Nevertheless, if the contract between the two says we will adjudicate it, let's say where I live, according to the laws of England and Wales, then when a Beis Din judges it, they will judge it by English law. They will not use Jewish law because the people made an agreement that the contract shall be interpreted according to the laws of England and Wales. And this is based on a concept that we call Dina de Malchus Dina. The laws of the country are the law. And therefore, that's a different concept, is which system of laws will you use? A Beis Din will generally use Jewish law, unless they're adjudicating a dispute which the contract agreement between the parties said, predetermined, that it will be adjudicated, or this contract will be interpreted according to the laws of England and Wales. This is what we call Dina de Malchus Dina. We'll be giving a share on that in Hollywood on Thursday night and in North Miami Beach Sunday morning on this topic of how do we synthesize civil law with Jewish law when a Beis Din is judging it. What we're going to do is just describe what is the process of taking a case to a Jewish court. You have a dispute with someone. Disputes are not all that uncommon. Maybe at the end, we'll give some advice of how not to get into a dispute in the first place. But you have a dispute with someone and you want to adjudicate it. You try your best to compromise, you try your best to talk to people. It's beyond repair, this relationship, and you want to adjudicate it in a Jewish court. So the claimant goes to a Beis Din. It can be any Beis Din you can choose, and I'll explain to you why, and ask them to send a hazbana. Hazbana means a summons. Send them a hazbana to come to Beis Din. The Beis Din will have the registrar of the Beis Din, the secretary of the Beis Din will send a summons to the respondent and say, so-and-so wants to call you to a Beis Din to adjudicate a case. Now, in Jewish law, the respondent, the person, the defendant, the respondent who receives this summons has two options. He has one option to say, yes, I'm coming on this and this date. Or he could say, I want to go to a different Beis Din. I don't want to go to the Beis Din that was chosen by the claimant. I prefer to choose the venue myself. And in Jewish law, the halach is halach achar hanitba. It is the defendant, the respondent, who gets to choose the venue. That's why I said before, if you have a claim, it doesn't make that much of a difference which Beis Din is going to send the summons, because more often than not, the respondent is going to say, I want to go somewhere else. You pick this Beis Din, then I don't want to go there. So it's really more of getting the process, starting the process, to get the ball rolling. And therefore, you start the process by sending hazmana. Now, of course, you should send hazmana from a Beis Din that you feel is confident, that they're competent and they're honest, because it might end up there. But like I say, sending the summons is just the first step in the process. The defendant, the respondent will say, I want to come, or I don't want to come. There's a third possibility. The respondent will just ignore it and say, I'm very happy. He has a problem. I have no problem. I'm quite happy with the way things are. Now, the halacha is, if a respondent ignores a hazmana summons, send 3 summonses. Once you write first summons, second summons, and then third summons. If a person does not respond after 3 summonses, the Beis Din writes something called literally it's called a siruv. That is a person who refuses to come to Beis Din. Literally, the word siruv means that you're putting the person in cherem, excommunicating him. People shouldn't have anything to do with that person. However, as the Aruch HaShulchan points out, it might be illegal in various municipalities to excommunicate someone just because they don't want to come to a Beis Din. Might be Jewish law, but civil law might not allow it. In England, it's absolutely prohibited. It's not only prohibited to excommunicate someone, but it's considered contempt of court, of the civil court, to say that there's something wrong with this person, that he doesn't want to go to court. And therefore, what you issue is something that's called a ksav lo tzayestina. This is a person who doesn't follow Jewish law. That's a hint to people to try to put some social pressure on him to show up. Furthermore, it's automatically that then the claimant can go to a civil court. Because you tried to bring the person to a Jewish court, he doesn't want to. He got 3 summonses, he refuses to respond. The Beis Din says, now you can go take this case to civil court. Now, as we pointed out, in Jewish law, the din is holach achar hanitzvah. The venue is chosen by the respondent. Now, historically, this was talking about every town only had one Beis Din. There's only one Kehillah, one community, one Beis Din. And it meant when the claimant lived in one town and the respondent lived in another town. And the claimant said, come to me, I'm calling you to the Torah in my town. And there the respondent said, no, you're calling me to the Torah, you want the case, come to my town. And that's the halacha. It's the claimant who's seeking some remedy. The respondent is quite happy the way they are, the way things are, and therefore you have to go to the city of the nitva, the city of the respondent. Now, what happens if both people live in the same town, but the town happens to have a few batei dinim? So the respondent calls someone to a Beis Din, let's say in Miami, and the claimant calls them to a Beis Din in Miami, and the nitva says, I'm willing to go to Beis Din, but I want a different one. Does the rule of holach achar nitva, the defendant gets to choose the venue, does that apply when they both live in the same town? And as in many things in Jewish law, this is machlekes. The difference of opinion, does the respondent get to choose the venue even if they both live in the same town? Usually, the answer is yes. It's because since the claimant wants the respondent to come, he's going to have to acquiesce to the will of the respondent. Nevertheless, at times, the Beis Din will say, I send a summons for my Beis Din. And the person says, I don't want to go to your Beis Din. To be my guest. However, give us a list of 3 batei dinim you'd be happy to go to. And then we'll let the claimant choose one of those 3. Like this will be more of a compromise. But intrinsically, it's the defendant that gets to choose the venue. Once you get people on the same page, they choose they're coming to this Beis Din. So the next step is to get them to sign a arbitration contract. And the reason is as follows. You can have it in Torah. 2 sides, each one presents their case. And the judges, the Yanim, will rule what Jewish law says. And then whoever loses the case will say, "But nice knowing you." And therefore, the only way to enforce a Beis Din judgment is if they sign a arbitration contract. And therefore, the Beis Din not only serves as a Beis Din of Jewish law, but it serves as an arbitration panel empaneled by civil law. And that's what I gave out to everyone here, a copy of arbitration agreement. And just like first, you see, you put the name of the claimant, you put the name of the respondent, and it says, we hereby refer this arbitration using my Beis Din, the Beis Din of the Federation of Synagogues, and a tribunal consisting, you have to name the 3 judges that are going to judge it. For an arbitration contract to be valid, and you have to name who the judges are, and you write what the case is about. In number 2, now an arbitration contract will say who is the claimant, who is the respondent, who are going to be the judges, Next, it will also define what are the terms of the adjudication. For example, A, who are the judges? Number two, the rights to issue interim orders. In other words, in pure, at least in English law, a arbitration panel's ruling is only enforceable if it's a final ruling, not an interim ruling, unless the parties specifically sign, we will accept interim awards. And therefore, if you read number three, the parties hereby authorize the Beis Din to issue interim rulings and orders. And therefore, you're authorizing the panel to do so. Next, you will also define what will be on what basis should the Beis Din judge the case. It can be Jewish law, it could be equity, what seems fair. In certain cases, like I say, the Beis Din will decide it based on civil law. I happen to be doing at the moment a very big charity case where someone's suing a charity. The charity is bound, although the people running the charity are Jewish, but a charity is a corporation which doesn't have any identity, governed by the Charity Commission. And therefore, we have to judge them. It's a Beis Din judging it by Charity Commission law. To be able to do this, that's not my field of endeavor, we included, besides the three Dayanim, an expert in charity law, someone who was a high court master in English high court, and he sits through to make sure that everything that we're doing follows British Charity Commission law. So you'll define what are the terms of engagement. Are we dealing in Jewish law, equity, compromise, civil law? Next, who's going to pay for this dinner? Now, in Jewish law, the costs have to be split equally. If one side pays more, then it's considered bribery. And you should know, sometimes it's hard to explain to a person. You call a person to dinner, and they say, I don't want to come in the first place. If the claimant wants it, let him pay for it. He's just wasting my time. And it's very understandable, but it so happens to be that if one side is going to pay for the dinner, this is the equivalent of bribery. Now, when I say the equivalent of bribery, it's not really bribery. Bribery would mean when the judges, the Dayanim, take the money of the dinner and they pocket it. It happens to be, let's say, I run a Beis Din, I get a yearly salary from the Federation of Synagogues, and my job is to adjudicate cases. It makes no difference to me who wins, who loses, how many cases I do, what are the size of the cases. They're exactly the same because I and my two fellow judges happen to get a yearly salary, and any money that's collected just goes to the organization, which ultimately from this and from other revenues, such as kashrus and cemeteries, they do fund. They do fund our salaries. So it's not direct bribery because we never see any of the money. The money goes to the organization, and the organization pays us yearly salaries, regardless of outcome. But nevertheless, the costs have to be split even. Now, let's get to an actual case. We've summoned the person. They came, they agreed, they signed terms of engagement. Who's judging this? Who are they judging between? Another thing we write out is this in a personal capacity or in a fiduciary capacity? Are you suing the respondent as a director of a corporation or in a personal capacity? That also is included in the thing. Who's going to pay for it? If many times a Beis Din has to call in a independent expert for advice. You're judging a tax matter, you need advice of a tax lawyer. We are judging a business was sold, and the person claims that he overpaid for it. Now, how am I going to judge what's the value of a bakery in Stamford Hill? Bring in an expert in business evaluation. So it's written in here that both sides will equally pay for the expert advice. Now the fun starts. Now we get to the actual case. I just set up now what is the process of calling someone to a din Torah and signing the arbitration agreement, which will then define the terms of the adjudication, furthermore allow the enforcement of it. Next, you start the case. In Jewish law, the halacha is niskaken l'teveya kila. The claimant always gets to speak first. You have to let the claimant talk himself out. Everyone needs their day in court. The truth is, anyone who is a professional judge or professional lawyer knows that most of what people say are totally extraneous to their case, and sometimes it's even absolute nonsense, and it undermines their own case. But you have to let people talk. And therefore, the claimant gets to say everything they want to say. Then the respondent gets to refute that. And this can go back and forth many times until everyone feels that they said their piece and they were heard. However, in every round, the claimant presses the claim first and the respondent always gets the final word. That's how the engagement is. The next issue in a Beis Din is, can you bring counsel, representation, which in civil court we call them lawyers, attorneys, solicitors, barristers, QCs, KCs now, all the QCs turned into KCs now that King Charles took over, or in Jewish law they're called Toyanim. Now Toyanim have a pretty negative reputation. Some of them actually deserve it also, but I'll explain to you as follows. In Jewish law, really, you should just let the two parties, the two litigants, state their case. And they should not have representation, because if you want to get to the truth, you have to hear it from the people that are involved. The Gemara says if a person has difficulty presenting their case, they don't know how to speak, it's too complex, then they have a right of counsel. But in a perfect utopian world, you would have just the litigants speaking for themselves. However, we don't live in a perfect utopian world. And I'll explain to you as follows, that in many jurisdictions, the right to counsel is an unwaivable right, which means that a person has a right to counsel. And even if they agree to waive it, it's not valid. Their waiver is not valid because it's an intrinsic right of counsel. Now, if you would make up a Beis Din, many people speak, why don't you make a Beis Din where they don't allow Tayanim into the room? And the answer is very simple. In a utopian world, after Mashiach comes, we will. But in the real world, a psak of a Beis Din has to be enforceable in civil courts via an arbitration contract. If the arbitration contract, which makes it valid in civil law, and in civil law, the right to counsel is an unwaivable right, you cannot run a Beis Din that says you don't have a right to counsel, or even a Beis Din that will tell people that they should waive their right to counsel, because that would invalidate the arbitration contract. And that's why, unfortunately, disputes sometimes get a bit bigger than they should be, but it's an unwaivable right. Next thing is that the dayanim may not communicate with any side, with any litigant, without and not in front of both parties. We call ex-party communication. And you can only speak to both at the same time. If a litigant comes to speak to you, sorry, I can only speak to you when someone else, when the other side is there. They send an email, they have to CC it to all the parties involved. Many times people very, very innocently send the Beis Din an email send an email, and they forget to copy in the other side. And we have an automatic response that comes out, sorry, we cannot read it until you copy in the other side. This is both a concept in Jewish law. Menayin, how do you know that you should not hear one side without hearing the other side? This is one of the halachas of Lashon Hara. Furthermore, it is also in civil law, this would invalidate a arbitration contract if you communicated with one side without the other side. So basically, another thing that you write is, what happens if one of the dayanim, you can have very complicated cases, and then one of the dayanim takes ill or retires. For example, I took over a Beis Din. My predecessor was called Dayan Lichtenstein. He moved to Eretz Yisrael. On his 65th birthday, he stepped down, and now he was in the middle of a bunch of cases. He doesn't want to hear about them. He said, I worked for 33 years, reached the age of retirement. My pension is fully funded. I don't want to ever see another disputant again in my life. So now what happens? But they're in the middle of disputes, and these disputes can last years. So the answer is, if you look in clause number 2 of the arbitration contract, it says the parties hereby agree that the Beis Din can replace any of the dayanim with another dayan, should he be unavailable because if you don't do so, like I say, anytime a dayan retires, becomes ill, Chas v'shalom dies, or just is fed up with a case and just walks out, which has happened. Sometimes you get so fed up, the person just walks out, and then the arbitration panel falls apart, and then everything you've done over years falls apart, and therefore you have to include in it that you'll have to include that you have the right of replacement on the arbitration panel. Now, you hear the case, the complainant said his claimant said all his claims, the defendant responded, gave all their answers, and now the case is handed over to the Beis Din. Now, you look at the beginning of Pirkei Avos, it says, heavy misunim bedin. Don't rush, be cautious to judgment. And the Shulchan Aruch says it means that you cannot judge a case without thinking about it overnight. When you hear a case, sometimes you get a first impression, but when you think it over, you think, something, the story makes a lot of sense, but something's bothering me here. If this is true, that this shouldn't have happened, and therefore you have to wait at least overnight, and sometimes longer. Just each dayan has to think about it on their own. Then they have a meeting, and they discuss the case, and each one says what was their impression. If there's matters of Jewish law to research, so then they research it. Many times the law is known; it's more judging the facts or the presentation. Then you take a vote. And it says in Chumash, Achrei Rabban Lahatais, majority rules. If you have a Beis Din of 3 dayanim, any 2 can outvote the one, and that becomes the opinion of the entirety of the Beis Din. There are no split decisions. When you send a psak, you have to say, this was the psak of the Beis Din, and all 3 have to sign, even though one of them was screaming a day before that you're all mistaken, and you don't know what you're talking about, but it's irrelevant because the halach is achrei rabban lahatis. Once a psak is given, it is both binding in Jewish law and in civil law based on the arbitration contract. There isn't an appeals process in the sense that you could take it to a higher Beis Din. However, a litigant is entitled to say, Mehichan damtuni. Tell me, from where did you arrive at this conclusion? And then the Beis Din has to write out where they got these conclusions, so that if he wants to, he can use this as a platform to re-argue the case, but it will always be in front of the same Beis Din. This is a basic outline of what a Din Torah looks like. It might sound foreign to some of you. I do this almost every day of the week. So it becomes second nature. But again, you start with the obligation to Jewish law and to try the case in front of a Jewish Beis Din, send a summons. The summons will bring the respondent to this Beis Din or a different Beis Din. They then agree to the terms of the arbitration. That is signed. You have the actual case in which everyone has to be able to speak their part. Everyone has to be treated equally. It doesn't make a difference who the people are. They must be treated equally. Then one considers the case, votes on the case, and then we issue a psak in writing. This is just the process of it entire. Now I just want to make a comment. Why do people get into so many disputes? Now, you might think, I sit on a Beis Din and I see cases all the time. It's probably because there are some very dishonest and crooked people out there. And one is clearly saying the truth and one is clearly lying. But you should know, it does happen occasionally, but it's very rare. Largely what happens is you have two people who have totally different perspectives on the matter. And this comes about because people, when they enter businesses or agreements or partnerships, should really write out every last eventuality that's going to happen. All too often, when you get into a partnership or you get into a business, everyone enters with very high hopes. Everything's going to succeed. It's going to take off. We're going to make billions. We'll split it 50-50. And what's the problem? We're all going to be rich together. In reality, life isn't always the way you plan it out and how you would like it to be. The more people write in advance, how are we going to run this business? What is the objective of the business? I was doing a case recently. These were two partners. They used to be such good friends. They used to make sheva brachos for each other. Now they're at each other's throat. This one's screaming liar. This one's screaming crook. And I said, can I stop the case for a moment? See, I'm a dayan. A dayan is supposed to remain totally passive and just listen. But for 25 years before I became full-time dayan, I was a Rav. I was a communal rabbi. And this communal rabbi used to getting involved in people's lives. And sometimes I switch modes, so I fall back into my own mode. And I said, I want to stop the entire for a moment. I'm stepping down as dayan, and the old Rav in me wants to say something. I say, okay, you're not a crook and you're not a liar. But let me tell you what's happening here. Two people went into a partnership. They bought a nursing home together, two nursing homes together. You, Mr. A, are an older person who's financially established and bought into this business for capital appreciation because you one day want to leave an estate to your heirs. You, Mr. B, as a young person with a young family, and you went into this business for income, to produce income. This partnership can never work. It cannot work. It's not that you're a crook and you're a liar. I don't understand how it lasted 8 years in the first place. It should have fallen apart in the first month, and it's a tribute to both of you that it lasted so long. So now knock it all off, everyone, and stop screaming at each other. It's just an impossible partnership, and maybe you should have recognized in advance that it's impossible because you have totally different objectives. And now let's just split up the business in an amicable manner. And then took off my rough face and put up on my dying face and became impassive again. But I got the message across. So many times it's simply either things are not discussed in advance, and therefore people come with a different perspective, and for years and years they're seeing things as different perspectives. I've seen many times done cases where one person says, I am the boss and you're the employee, and the other one says, no, we're partners. And for years and years, this one's looking at a partner, and I'm putting in all my efforts because I'm a partner in the business. And the other one's looking, wow, he's a real dedicated employee. I should give him I should send him some Hanukkah gelt. And that's about it. And then one day it all explodes. The main reason that we see disputes is that people, when they enter a business or any relationship, should figure out how they're going to get out of it when it goes sour. If you're looking for a job and someone really wants you, you should include your retirement and your severance package in it when you take the job, because later it's just going to be a dispute. And every partnership agreement would be well advised to have, how do you break up this partnership? What is the process of breaking up this partnership? And the more people would put down in writing, the less disputes they would have in life. It's not all that often that someone is just out and out trying to rob someone. It's a difference of perspectives. Obviously, this becomes much more painful when you're dealing with family. Done cases on estates, and you see a brother and sister fighting with each other, or two brothers fighting with each other. And I implore everyone I meet, do me a favor, write a will. Because you think sometimes it's very painful to contemplate your mortality, but you should know that's one thing for sure. Everyone's going to die one day. And where there's money, there's a dispute. If you want to make sure there's no dispute, you have two options. Either leave nothing, or leave a pile of bills. That's one mahalach. But if you are successful, Hashem benched you in life if you're successful, please write it out clearly. It would prevent most of the bitter family disputes I've done in life have been because it wasn't clear. Occasionally, it's just plain sibling rivalry. I was doing a case and they were talking about a certain property. Was it owned by the father, or was it a partnership already with one of the sons? So therefore, how do you split it up? And the son showed that he was really a partner, 50% partner all along. So therefore, now he becomes a 75% partner. And all of a sudden, the other son got up, turned over the table and said, Dad always loved you more than he loved me. And therefore, we realized that they're not fighting about money over here. They're fighting about something else. Unfortunately, a Beis Din cannot adjudicate parental love or anything. We can only adjudicate whatever you can litigate. Like I say, twice a week, I generally do financial cases. Once a week, I do divorce cases. And a lot is the same, many times. It's unfortunate a marriage doesn't always work out. Relationships don't always work out. But just recognize it. It just didn't work out. And maybe it was a tribute that it lasted so long. But if you have to split up, so split up. It's not the end of the world. In Chumash, we're not Catholic. We do believe that people can get divorced. But do it in an amicable manner and look at it just as a simple business dispute. I understand the emotions are much higher there, and therefore you can't always adjudicate it as such. So this is what the obligation to go to a Beis Din, the process of a Beis Din. Now I just want to go through some exceptions to the rule. What does not belong in a Beis Din? Step one, you can't take a non-Jew to a Beis Din because he won't come. Someone who doesn't keep halacha is totally unobservant. He's not going to come to a Beis Din, and therefore you don't have to. Someone who's a true criminal, or the criminal underground, drug dealer or whatever, these things do not belong in the Beis Din because Beis Din does not have those enforcement powers. A question that we get very commonly is as follows. I was in a car accident with someone. I want to collect insurance. I can't go to a Beis Din to collect insurance because Geico is not paying. What? And they're not Jewish. However, technically, you cannot sue an insurance company. You sue the person who you got into an accident with, and the insurance company indemnifies that person. So I have to sue. Now we're both Jewish people, we're down in the same shul, and backing out of the backyard, in the parking lot, you smashed into someone. And here we come up with two questions. The suit is you're suing another Jew because you want to get to the insurance company. And we have two separate questions here. As we started out, the prohibition of going to court is twofold. One, that they're not using Jewish law, they're using civil law. Number two, that you're supposed to go to a Jewish court even if the laws are the same. Now, the second part, we could say, listen, if I want to collect from an insurance company, I cannot go to a Jewish court because they won't pay. If I have to go to a non-Jewish court. But we still have another issue that the court will judge it based on civil law, and really we are bound to Jewish law. And the answer to this is, and this is a very common question, that driving is a licensed occupation. You cannot drive, you need to have a license. One of the rules of licensing is the jurisdiction will not issue a license unless you have, and you'll get a license, but you cannot drive a car unless you have insurance. If you have insurance, you must have insurance. Since this is a licensed activity which requires you to have an insurance, anyone who gets into a car has made an agreement with the other person driving a car that we will follow civil law in regards to insurance claims. This is true about suing a doctor for malpractice. This is true about any licensed industry which requires a person to have insurance. You're allowed to use civil law because it was a free agreement, and you have to use a civil court because the insurance company will not pay otherwise. The question I regularly get is, okay, I'll sue a Jew in civil court to be able to collect from the insurance. Now, his premiums are going to go up. Am I obligated to indemnify him against the premiums? Now, when you're going for a big suit, many millions, you're talking about pennies. So you might as well be a nice guy and do it. But you want to know if technically you're obligated to indemnify him against the rise in his premiums. I believe not, for two reasons. One, his premiums should rise. He gets into car accidents, and therefore he's a higher risk, and therefore it should charge more. Furthermore, the premiums rise, it's on future insurance. It's not on prior insurance. If he stops driving right now, his premiums won't go up. So it's his decision to continue driving, even though he got into an accident, and therefore I don't believe that technically you're obligated to indemnify the person. Morally, maybe yes, maybe no. Next is to certify things, not to adjudicate matters, but to certify matters. For example, you want to certify a sale, a will. Any of these things are allowed to go to court because it says ve'ela hamishpatim. Mishpatim means adjudication. Adjudication should be done in a Jewish court. Certifying something or registering something is not an adjudication. There is a question, what about enforcement? Let's say in Jewish law, I'm entitled to this money. Am I allowed to go to civil court to enforce it without the permission of a Beis Din? And this is a machlekes, it's a dispute. Is enforcement a form of adjudication or no? Adjudication is arbitration. Enforcement is something which is permissible. And if you have such a thing, ask your rabbi. Next is putting on a restraining order. In England, they call it a freeze. You want to freeze someone's assets because you're scared by the time I'm going to call someone to Beis Din, but maybe by the time the case is over, there'll be nothing left. And therefore, I want to put a restraining order that the person shouldn't be able to spend their money. Is that permissible to go to a civil court just to use it as a restraining order? And the majority of opinions say yes, you are, either because that's not a form of adjudication, or because there isn't any other way of addressing this matter other than going to civil court. What you do is you write a restraint, in the restraining, you make an application for a restraining order, and you write in it that I'm willing to adjudicate it in a Beis Din, but I need the court for restraining purposes. So like I say, the notable exceptions are when you're dealing with people who will not follow halacha, or when you're registering a fact, a sale, a will, not you're adjudicating something. A restraining order is usually permissible, but ask a shayla before you do it. And enforcement is also usually permissible, but ask a shayla before you do it. That's a basic introduction to what a practice of a Beis Din and a day in the life of a dayan, and we'll take any questions. Yes.
So a lot of people, I'll say women, if you get married, if you love me, we don't need to do a prenuptial. Some people say it's against halacha to do a prenuptial. Some the Orthodox people will say you need a prenuptial because you want to put in that you need to get a get in case that there's something there. So I wanted to get your opinion on whether you think it's against halacha, it's not a good thing to get a prenuptial. Actually, it's a very good thing. As a lawyer, I think it's a good thing because it's up front, or at least fooling anybody later on if something goes wrong.
Right. So the question is about writing a prenuptial agreement for marriage. Based on the advice that I gave before you get into a partnership, you should already write the breakup of the partnership. So why don't you do the same thing by marriage? And the truth is there are many different types of prenuptial agreements. One is simply if we have a dispute, we hereby agree to arbitrate it in this Beis Din. This, I don't see any problem with it in Jewish law at all. Whether it's valid in civil law depends from different jurisdictions. For example, family matters are not valid in New York State law to be judged by a Beis Din, but they are valid in New Jersey, for example. But a arbitration contract on a financial matter is valid in New York State law, even if they arbitrate on Sunday, but not in New Jersey, because New Jersey has blue laws. We are not allowed to operate on Sunday. So if you want to arbitrate a family matter in a Beis Din under civil law, if you live in the metropolitan area, you got to do it in New Jersey on a weekday. Don't do it in New York, and don't do it in New Jersey on a Sunday. In England, it's not valid at all. You cannot arbitrate a family matter under a Beis Din and have it enforceable. So largely in the jurisdictions that I practice, the prenuptial is a very good idea. It's just not valid at all because it's a family matter, and arbitration contracts are only valid in financial matters. The question in Jewish law on a prenuptial is when you write an agreement not merely to arbitrate it in front of a Beis Din or to give a get when asked or whatever, but that you provide a penalty if one side wants out and the other side doesn't want out, and you provide a penalty which is excessive. Not a penalty of what it costs to live or losses, but a penalty which is excessive. When a get is given under the duress of a financial penalty, it's, according to many opinions, it's not valid. So when we talk about a prenuptial agreement, there are two different types of prenuptial agreements. One that pre-imposes a penalty, and if it's excessive, it will just invalidate the get that comes afterwards. There's another one which will not predetermine the outcome of the case, just bind the people to arbitrate the case and adjudicate the case in this Beis Din in this manner. That has no question in halacha, but whether it's valid in civil law depends on the jurisdiction that you practice in.
What about a normal prenuptial, which we'd say, for instance, we get divorced, this is what you're going to get, for economic. It's economic.
Pure economics would be valid, but again, the economic one will not force the divorce. It will just tell you what happens after the divorce. The person's writing it is because they want to ensure that there is a divorce. The only way to do that is with a penalty clause. If the penalty clause is mild, they won't insure it. If the penalty clause is excessive, it will invalidate the get. That is, now you understand what the underlying issue is. I can write an economic agreement that if we get divorced, we're going to split the house in two. That's all right. Anyone's allowed to write that. But it so happens to be that will not cause the divorce to happen. That will just tell you what will happen after the divorce.
Right, and that's not.
That's not problematic. That's not a problematic in Jewish law, but it won't accomplish what people are trying to accomplish. In other words, in a business partnership, we can not only write what happens after we split the partnership, but we're going to write what will force someone to split the partnership. In Jewish law, a get which is not mandated by Jewish law, which is forced, will not be valid, and therefore you just outsmarted yourself. That's the problem. Therefore, it takes a lot more effort.
And how do they do it? Because they're doing it now, right? They're putting in.
Like I say, many of them are just very generalities. Many of them are just generalities. Many of them are not excessive. They're just saying that if you refuse to give a get, so you have to continue to support me as long as we're married, like a married couple, which that's just really formulating something in a pre-existing law. The problem is when the get is forced by a penalty which is excessive. And like I say, it depends very much on various jurisdictions. For example, like I say, in England, you cannot, a family matter, custody, cannot be judged by a Beis Din. What about the breakup of assets due to the divorce? Is that a family matter or is that a business matter? Is this a breakup of a partnership or is this a breakup of a family? And interestingly enough, in British civil law, is if the divorce was given already and now you're discussing the finances, then it's just a partnership breakup. Because the marriage is already, the relationship is over, and now you have two business partners who want to break up. That a Beis Din could do. But the adjudication of the business matter before the divorce cannot be done under law, or it won't be enforceable in law because it's a family matter.
You said, what about representation? Would someone doing the Beis Din, would they represent themselves or would they have an attorney?
Like I said, they have a right to bring representation. As we said, it's an unwaivable right. The right to counsel is an unwaivable right in civil law, and therefore everyone is entitled to
But does
representation.
it make a difference? See, because like, let's say in Florida law, you have a right to represent yourself,
Yes,
but then you have to know all the rules and procedure and evidence, which would be basically killing yourself.
right,
Ridiculous to go to court unless it was small claims.
right.
And even then it would depend.
No, in a Beis Din, it wouldn't be necessary. It's not necessary to have representation because you don't have to know the procedures. You just have to tell a story. And if you tell a story honestly enough, the truth will come through. If it's more complex, then you need representation. But it's something that one has to allow the right of representation. Yes.
I know you mentioned divorce cases and
Yeah.
financial. Have you ever seen cases like Monsey or like libel? Or like
Yes.
Gemara gives a case of someone stole the beracha of someone and he had to pay 10 gold coins.
So the answer is like this. It says right away, the beginning of Chesed Mishpat, Siman Aleph, that today we don't judge knossos, things that are penalties. So therefore, a Monsey Shemra, I did one Monsey Shemra case, I'll tell you, it's very interesting. But the person says, you libeled me, you slandered me, and therefore I want $10 million. A Beis Din can't judge it because that's a penalty. What you can judge is if the person had a loss of income because of it, a financial loss, then you can adjudicate the financial loss. And therefore, when we have slander cases, it's more the person slandered me, slandered my honesty, slandered my business, and therefore I lost customers because of it, and I want reimbursement, compensation for that. The actual loss of reputation, which doesn't have a financial implication, a Beis Din cannot judge. In my youth, although, like I said, I became only a full-time judge 2 years ago, but over the past 25 years, I sat on various Bati Dinim, and I started off in Washington Heights. And there was someone there who ran for government position, and someone else slandered him that he's a crook and whatever, and nobody should vote for him. And he lost the election. And the loser of the election took the journalist who wrote the article against him, took him to Beis Din for slander. Because of you, I lost the election. Now, okay, this is a case where for many reasons should not have come You can't collect it. Now, what happens if it comes to a Beis Din? It comes to a Beis Din. Now, there is a concept called Dina de Malchus Dina, that you follow the law of the land. Will the Beis Din say that after 6 years the debt is canceled? We had this case not long ago, and we did some research. And this is an interesting question in civil law. Does the statute of limitations waive the debt, or does the debt still exists? It's just the rights of collection in court are forfeited. And it turns out, at least in England, it's the latter. Now, if the debt exists, just the rights of collection in court are forfeited, well, then the rights of collection in Beis Din will still exist. If, however, in civil law, the debt itself would be waived, and the assumption here was that this partnership or this interaction was governed by civil law, then the Beis Din would waive the debt also. So it depends on, but there's no intrinsic statute of limitations.
Civil is 10 years.
It's just for judgment. It's the type of judgment, not the flood.
Yeah.
What about evidence procedure? So what is how would the Beis Din rule on procedure? How would they make decisions based upon Jewish law and evidence? And then let's say it says there's a contract or something, would you then not use Jewish laws of evidence and use, let's say, state of Florida law of evidence,
Okay.
hearsay, or whatever the
So
procedures are?
the answer is twofold. One, in just pure Jewish law alone, you need to have 2 male adult witnesses who are not related to the parties. That's very hard to come by as evidence. And it already says in the Rambam and in other people that in cases where that's unlikely to happen, then the Beis Din could judge based on any evidence, and they take the evidence and see, does it create an assertion in their mind that's beyond a reasonable doubt. Then if the contract says that this will be judged or interpreted according to the laws of the state of Florida, then we use the evidence rules of the state of Florida,
So then
not
you-
of Jewish law.
So then we need lawyers who would understand what the evidence of Florida
That is correct. So every Beis Din either has a bunch of lawyers that advise them, hopefully pro bono, or you have some, a judge. Generally, we all have retired judges that advise us on matters, because after a while you pick these things up because you do cases all the time, and one knows oneself what civil law says on it. Because after you do enough cases in the state of Florida, you just eventually pick up what are the laws in the state of Florida. Anyone else? Yeah.
Is the prevailing party given awarded attorney's fees and filing fees?
In Jewish law, no. In Jewish law, unless it's a frivolous case, unless it's proven it was frivolous, but if it was a real case and each side thought they were right, then each side has to pay their own costs. But intrinsically, the costs aren't that great because you can represent yourself, and the Beis Din fees are not, compared to Beis Din fees, also generally go on a sliding scale depending on the size of the case. The smaller the case, the smaller the fee. So the costs aren't as great, but to answer your question, no, it doesn't follow.
What's the difference? Let's say we have a lot of rabbis here. So the difference between being a rabbi and
You're dying.
yes,
Okay.
and what is the difference between what a dayan can do and a regular rabbi can do in resolving disputes?
Okay, it's 2 separate things. So it's like this. To become a rabbi, the Shulchan Aruch is divided into 4 parts. Orach Chaim, daily life. Yeredeya, which is like rules of kashrus and, not rituals, but religious law. Chesed Mishpat, financial matters, and Eben Ezer, marital matters. A rabbi is expected to have learned Orach Chaim and Yeredeya. A Dayan is expected to have learned Chesed Mishpat and Even Ezra. It's a different field of expertise. A person could be both if they studied all of it, and it's a different field of expertise in Jewish law. But in the role they play, rabbis largely act as mediators and occasionally arbitrate something, while Dayanim act as judges. And like I say, it's much more passive. I've been both, so it's a different role. One, you're passively listening, and just trying to discern the truth as presented by the arguments, and one, you're actively trying to come to some resolution. As a matter of fact, in my Beis Din, we happen to have 4 Dayanim, myself, and I have 3 judges work under me. Now, Beis Din can only have 3 because it always has to be an odd number. So why do we have a 4th Dayan? And the answer is, on every case, when we get a case, we decide which 3 are going to arbitrate, and the 4th one is appointed as a mediator. And first, you have to go to the mediator and see if he can come to some amicable resolution. This mediator cannot serve as an arbitrator because he got information that wouldn't have been presented as in a court. Not only that, he's not allowed to communicate with the other 3, even though we work together. So in every case, we decide who would, of the 4 Dayanim, each one has a different skill set and a different personality, who is the one who's going to first mediate it, which is more of a rabbinic position. And when the mediation fails, or if it fails, when it fails, they send it over to the arbitration panel. So we first pick the mediator, and the mediator might be, we have a young person who is a professional mediator, has a degree in mediation. Sometimes we take the most senior Dayan, man 70 years old with a flowing white beard, and he sort of calms the people down and says, don't fight so much, life isn't so long. And we take different people are chosen for different things. I usually do not mediate. I don't have the patience to do so. So I can just give you an answer. But I have some very good-hearted colleagues who will put the effort into it. Yeah.
Are there any countries or places where a Jewish court is forbidden?
I'm not aware of it. There are issues that you can't judge in the Jewish court, like say family matter, but that it's totally forbidden, I don't think so, because you can agree to any arbitration panel. You can agree that it doesn't have to be a rabbi. You can agree that your neighbor should do it, or you can both agree that your grandfather could do it. So therefore, since we're working as an arbitration panel, not so much as a Beis Din, it should be fit with almost everything. I don't know all the laws.
I know that in Shulchan Aruch you have the Shach and the Taz.
Yeah.
What happens when you have an Ashkenazi, Sfaradi, or like Chabad come in and it tells you, hey, you're ruling it on the wrong?
That's on ritual matters. Financial matters, generally, to be Monsey moment, to take away money from someone, it has to be a ruling which is agreed upon by all. As opposed to ritual matters, whether you're going to daven Marav and what Nusach you're going to say depends on your Masorah, on your heritage. But when you're dealing a financial case, unless everyone lines up that the person that is obligated to pay, they won't have to pay. Yeah.
After you rule that a person owed money to another person.
Yeah.
How you adjust that value if that was a couple of years ago, and today that money doesn't have the value of today, that it's called today inflation.
So it's very simple.
On civil law, you are entitled to charge interest.
Right.
But
Jewish law
Jewish
doesn't allow
law, no.
interest. So the short answer is that debt, if it's a debt which is contracted via a loan, there is no recourse in Jewish law because it's ribbit. If it's a debt which was contracted by a different form of obligation, then if there are damages, then you can recoup those damages. That's the short answer. The long answer would take an hour or two. Yes.
As far as being part of the Beis Din, if a person wants to become part of the Beis Din, is there any requirements
Well, one first has to learn Chesed Mishpat and Even Ezra, the body of Jewish law, discussing financial matters and family matters. You get tested on it. Then you have to intern. You have to intern to watch other people doing it, because there's a difference between how law looks in a book and what law looks like in the real world. Let's even take something as technical as doing a divorce, doing a get, which is really a technical matter, and you have to learn through Hilchos Gittin. Starts in Kuf Tes, ends Kuf Nun Dalet. So seemingly you learn 25 semanim, and there isn't anything more. But then you have to go watch someone do it. When I finished learning Gittin and I was tested, I was in Monsey then, Rabbi Landesman tested me, wrote me a smicha that I can do a get. Then I went to Eretz Yisrael. There's a famous dayan there, was nifter recently, called Rabbi Shlomo Fisher, and I watched him do 150 divorces in 5 weeks. The last day, I only worked 3.5 hours a day. The last day before the summer vacation, everyone wanted out. They wanted to be free for the summer vacation. He did 12 gittin in 3.5 hours. And I remember telling him, if you divide 12 into 3.5 hours, it's an average of 18 minutes each. I said, these were people who are matzahs, they would be kosher. The matzahs they bake the less than thing. So watching someone do 150 gittin in 5 weeks gives you a very intense education in how to do it. Because you might know the rules, but let's say in writing a get, one of the questions is, how do you spell the name? Now, you have some very classic names that are found in Chumash, but many names are secular names, Arabic names, and you're going to have to know how to spell them. And the only way to do that is by watching people who have learned it from other people. So there's interning. Same thing as being a dayan. I sat for quite a while in front of a very famous dayan of Zalman Nechemia Goldberg. I watched him judge cases, and then before he would issue the psak, he would say, "What would you have said?" and tell me why. And after a long time, you think. So it's a question of learning the knowledge, getting tested on the knowledge, then shimush, and then eventually, if someone hires you, then that becomes your occupation.
Rabbi, you just brought up something I want to ask you. Spelling the name correctly.
Yeah.
So my Jewish name is Minna Yen.
Minna
Minna Yen.
Okay.
So when I was a teenager, I wanted to get a charm with my name in Hebrew.
Yeah.
So when I asked my father, I said, go ask Uncle Joseph, because he was the greatest. He was a Rebbe in Baltimore.
Yeah.
So he spelled it Mem Yud Nun He, Ches Yud Nun He. I don't know what's written on my ksuva. It could have been maybe Mem Yud Nun Ayin. But what I'm thinking about now is, my husband passed away. Do I really have, what spelling am I going to put on the matzeva after 120?
Okay, that's called planning ahead. So like this. Really, the rule of spelling is that Hebrew names end with a hey, and Yiddish names or any other language names end with an aleph. Therefore, Minna should be spelled Mem Yud Nun Aleph. However, people who live in Israel spell it the Hebrew way. But barring that, a Yiddish name ends with a aleph, unless it's a diminutive of a Hebrew name. For example, I really just recently did a get on 2 women. They were both called Tilly. Tilly is diminutive of Tila. But one of these women, her name was Tila. The other one was her real name, or she was named after her grandmother, Tehila. Now, although the name is the same, everyone calls them both Tilly, but the one whose name was intrinsically Tila was Tes Yud Lamed Aleph. The one whose name was really named after Tehila, her name was Taf Yud Lamed Hey. So it's been. So again, without knowing the whole family history, but as a general rule, you would end it with an Aleph if it's a non-Hebrew.
So, okay, so then let me backtrack. Should I go ask someone in the family to see what's on my bubby's matzeva? Because I'm named after a grandmother. My husband was Israeli, and he would always call me Mina.
Right.
So again, I don't know what am I supposed to do with the.
And this
Stay
name,
alive.
what? No, this name is used, it's still used in the religious context.
I don't use my
When you
my
daven.
Jewish name. No, I do.
Yeah, when you
but
daven.
When I came to New York, I would say my name is Madeline.
Okay.
And then there were some families that were close to me and I was a bus biased by them. So they would call me Fiona.
Okay.
They like Fiona better than Minna. But really, I want to know, what am I supposed to do?
Again, you could look at your grandmother's grave. I'll tell you, I did that when I got married. My name is Shraga Feivel, and Feivel is spelled Fei Yud Yud, and some people do it Beis Lamed, Beis Lamed, and some people do it Vov Vov Lamed. I didn't know how to spell it. I myself have spelled my name many times different ways. And when I got engaged, the Sadhu Kedushin asked me, how do you spell it? I said, I don't know, every day I spell it differently. They said, be so kind, go back to the grave of the person you're named after, which was in Rasvadine, Romania, Nojvarad, Romania, and see what it says there. And sure enough, it said it with a base. And since then, the rest of my life, I've spelled it with a base. So it might be a thing, but like I say, in the absence of any other indicator, usually a Yiddish name ends with a. But it's only negaya really for a ksuba and for a get. Again, a matzeva doesn't have to have a name even. You can have matzevas without it. So it's not this thing. It's just really you should live out Me'av Esrim and be healthy. And one day people want to name children after you. They'll want to know how to spell it. That's what it's negaya. There's no intrinsic thing that a matzeva needs a name. In Hebron, you have matzevas without any names. Yeah.
When you have sexting is there arbitration, do you register it in the civil court or no need?
If they comply with it, we don't register it. And if they don't comply with it, we tell the litigant to go register.
Okay, but you say that they have a way to just review the whole arbitration again if something was wrong, or they think that something was wrong with that.
Again, unless you're going to prove bribery, the court won't touch it. Courts are, again, they're bound to arbitration contracts. And to be honest, courts are so overloaded today that they're sending cases to us. Now, they're not overturning cases. They're interested in offloading as many cases as possible. But we recently had a case where Bezdin wrote a psak. The person didn't comply with it. The person registered it in court, and then I was called to testify in court on the basis of the psak. And so I did so, and they accepted it.
So the thing is not registered it.
No, you could register it, but it just
like a closed case in terms of.
again, if the person complies with the psak and they pay up, so there's nothing to register. If they don't, then you register it. And like I say, I've been called to court to testify on it. As a matter of fact, the last time I testified was a divorce case, and the judge said, "Rabbi, what do you do when you're so overloaded with cases? I just can't manage anymore. What do you do?" I said, "I don't take any more cases. I only take as much as I can manage." The judge said, "What? I can't do that. I'm a public servant. I have to take a case." So I said, "And Judge, Your Honor, you deserve a raise." And the whole courtroom erupted in applause, and we won the case. Yeah.
Which system is more favorable to Jewish law, American or British?
Don't know that there's that much of a difference, because as long as you sign an arbitration contract specifying that it will be judged by Jewish law or Swahili law or Zulu law, it's valid in all jurisdictions. The difference might be in family matters, but in financial matters, they're exactly the same.
What's the reason why you're allowed to take, let's say the respondent wants to go to civil law,
Civil court.
civil court, what's the reason why you're allowed to go to civil court? Meaning, it's Elam Shpatin, you should go through the Jewish court. What's the reason, according to Torah, why you're allowed to go to civil
If
court?
the respondent wants to go to the civil court, he's not allowed. Goes the other way.
Yeah.
If the claimant
Or,
calls you,
sorry,
to-
sorry, the claimant, yeah.
the claimant calls you to a civil court, then you're allowed to go there.
What's the
Because you
reason?
didn't, because the Chil Hashem is choosing the court. If you didn't choose it, you were forced into it, then it's permissible. Okay. This close, we should have no more disputes at all,
Amen.
and
Can I ask him, on the record or on the?
It's off the record.
Whatever, how can I make time to see you?
I'd be happy to make that.
Depends what you wanna see me about.
He's on vacation.
I think with you, I have a very good chance of collecting my money.